Welcome to Heald Law Academy, the place to understand how to grow and protect your business. Today I'm with Ruth Burrell, who's a solicitor in the Commercial Property Department at Heald Solicitors LLP, and we're going to find out about how a tenant of a property can request a new lease. Welcome, Ruth.
Hello.
So how can a tenant request a new lease?
Well, if they are in a property under a lease which is known as a protected lease, back in 1954 the government legislated so that any tenant of a business premises could stay in the property at the end of the term and had the right to request a new lease. So if a tenant hasn't signed a statutory declaration or a declaration to say that they're going to leave the premises at the end of the term, then they probably have the right to remain and can request a new lease.
Okay, Ruth, so are there any risks to the tenant remaining in the property at the end of the term of the lease?
Yes, there are. The landlord does in fact have rights that they can take back occupation of the property, and they do have rights to oppose a request for a new lease, and there's 7 grounds that the landlord can use, and these are on the slide now. The most common ones that are used are that the landlord wants to use the property for their own use, or that they want to refurbish or demolish and reconstruct the property for their own use, and obviously can't do that while the tenant is in occupation.
How could a tenant, let's say, protect their position when their lease comes to an end? Is that possible?
Yes, the tenant will stay in the premises at the end of the lease, and they are there, and it's called holding over on the terms of their current lease. But this isn't a very satisfactory position for the landlord to be in, because the tenant only has to give 3 months notice before they vacate the property, or they may not vacate the property, and the tenant could be in there for a few more years. The landlord will obviously want more certainty than that, so they will serve a notice to say that they are happy with the tenant staying there, and they'll offer a new lease, but on the terms specified by the landlord. If the tenant is looking to stay in the premises, the better way for them to do it is to serve their own notice, so get in there first, serve their notice and propose their own terms for the new lease, and the landlord then has to come back on those terms. If they don't come back on those terms and they don't serve a counter notice within the specified time, then the tenant gets a new lease on the terms that they've proposed.
Is there anything that a tenant needs to be aware of when requesting a new lease?
Yes, before they put in a notice for a new lease, then they need to know that the notice can't be withdrawn. So the notice will specify a termination date, and if they don't want or they don't continue with the new lease, then their current lease will actually terminate on that date. So they have to be very sure that they do want a new lease and the terms that they're proposing. The courts can also impose a interim rent, but this is a whole other subject for a later date, I expect. But the tenant must be very aware that the courts can actually impose a rent on the lease going forward.
Okay, I mean, it's all very well for large corporations and large businesses, but what about smaller businesses? Would you say it would be good to arm yourself with a good solicitor or look over your rights before you get into something like that?
Of course, because this isn't something that tenants should be going alone. Really, they need advice from both surveyors and solicitors.
Well, thanks very much, Ruth. Okay, folks, well, that's it for now. Please remember to subscribe to our videos, news and events, and feel free to use our website or social media to ask any of our legal experts any questions you may have about commercial law. Bye for now.